The association increased in members, but really didn't gain a whole lot in members throughout the 1940s. It was pretty constant where it was. Judges couldn't be members. You couldn't be a member if you practiced law for the state or for the county. You had to basically have your own individual office in the county and practice law here regularly. I found it fascinating that even as late as the 1970s, the late Judge Robert Murphy was denied membership in the Baltimore County Bar Association because he was an attorney general. And as an attorney general, he was not eligible for membership. And so he was denied to become a member of the Baltimore County Bar Association and never became a member, to my knowledge, a member of the Baltimore County Bar Association. It really was not until the Bar Association had some real issues with who was the members and who weren't in the 1960s that membership started to open up and expand. By the time you got to the 1950s, again, a lot of people had come out of World War II, out of the Korean War, looking, Baltimore County was growing by leaps and bounds in those days. You had all the post-war housing, issues like that. The Bar Association, the number of people who became attorneys was growing rapidly. And you had this tremendous expansion. Bob Ramacka told me years ago that there were only a couple ways in which you really found success as an attorney back then. One was through politics. You got involved in politics and going around and trying to get jobs and things like that through people that you knew. Maybe you could get appointed to the district court in those days, or people's court, court of common pleas, whatever. Or you basically hung out and you became members of some social group, whether it was the Elks, or the Moose, or the Optimists, or the Odd Fellows, or Rotary, or something, and you sort of came up with your social contacts and tried to grow your practice that way. Again, there was a lot of threat from all these attorneys in the city coming out and trying to practice. So there was a lot of pressure on the Bar Association to expand, and a similar pressure on the Bar Association to keep things restricted. Because in those days, again, they had control over the grievances. They had quite a bit of say in the judicial nominations, because there was no judicial nominating commission. So they got to send and recommend directly to the governor whom should be appointed as judge. And you only had a handful of members as members of the bench. I went back and took a look. In 1950, Baltimore County had 3 judges. You had the chief judge, Gus Grayson, who also served on the Court of Appeals. You had Judge Coburn, who was really Harford County's sole judge. You had J. Howard Murray, and you had my grandfather. And those were the judges in 1950. By 1960, you had my grandfather, you had Stuart Day, who was judge up in Harford County, and then you had Lester Barrett, Judge Rain, Judge Mencheen, Judge Berry, and Judge Lindsay. Not a tremendous expansion in the number of judges, but if you were a judge in those days, you had some real power going for you, because you basically had control over the courts and everything in it. County government was far smaller in those days than it is today. And there was a lot of political say as to what happened, who got appointed to which positions, and it was all political appointments. And the Bar Association had a tremendous say over who became judge.
One Republican judge, Lester Barrett.
And Lester Barrett was the one Republican judge. But that wasn't so much a deal of, and that was a legislative deal more than it was anything else. By 1970, you had far more judges, and you also had a district court coming into being. And the number of judges had grown substantially. But in the 1950s, things were pretty slow. Baltimore County was publishing its rate manual. It had a manual of a minimum fee schedule that attorneys could charge for things. It revised those books even into the 1960s. And upon admission to the bar, you were basically given a booklet stating what were the minimum rates you could charge for doing up deeds, recording simple documents, things along that line. Because, after all, business was business, and you didn't want to be undercut because of the competition coming in. Similarly, by the 1960s, there was real concern about the exclusivity of the Bar Association. They kept trying to amend the membership, and by 1959 there had been this statement where the membership was amended to include anyone admitted to practice in the circuit court for Baltimore County. And most of you remember that you had to be admitted before the circuit court in order to become a member of the Bar Association. You got sworn in before circuit court. But you also had to be a resident of Baltimore County, and you had to have been actively engaged in the practice of law in Baltimore County, and should have maintained an office in Baltimore County, such office being the main office of the applicant and the law firm, for a period of 1 year. Now, if you had been elected prior to 1959, you could be grandfathered, but part of this was that you couldn't then leave the office and remain a member. So if you retired or you left that office, your membership wouldn't continue. And that was part of it, because we saw the growth of the downtown law firms. Were starting to really kick up in number, and they had satellite offices, so that, for instance, for a number of years, people were trying to get attorneys who were practicing here in Towson, but a member of a downtown firm admitted to the County Bar Association, and it wasn't going to happen unless that law firm declared their Towson office as their main office. So, if you didn't have that office in Baltimore County, you weren't actively engaged in law in Baltimore County, or you ceased to be a resident of Baltimore County, you could be removed from membership. No judge was allowed to be a member. And so if you became a judge while you were on the executive committee or while a member of the bar, you had to resign. Now, the first woman who was admitted to the Bar Association was Jackie McCurdy. And Jackie McCurdy and subsequent women for the next few years who were admitted, she was elected in 62. Dorothy Jackson was elected, was the next one in 63. And in 64 you had Barbara Goldberg came in. And throughout those years, they were not permitted to come to the bar banquet. But not only were they not permitted to come to the bar banquet, it was a practice of the Bar Association to invite members of the city and the county benches to the banquet, except for Judge Shirley Jones. Judge Shirley Jones, who was on the court bench for Baltimore City, was not invited to the banquet. It was stag only, women were not permitted. It didn't matter whether you'd been elected as a member to the association or you were a judge, you were not invited to the bar banquet. Well, that got to be a little bit much for some people, and it also got to be a bit much as to the control of it and things like that. The Bar Association had never been real formal with the legal niceties, and I guess that may be typical of lawyers generally, that when it comes to their own legal affairs, they're probably last in line to get things done. Well, the Bar Association had never incorporated until 1928. Formed, but just didn't incorporate. And then they allowed their charter to lapse in the 1940s. Well, by the 1960s, there got to be disputes as to who was a member, who couldn't be a member. Were they too exclusive? The Bar Association became a club. So, in 1965, the Court of Appeals came down to say, well, who should we recognize as submitting recommendations for judges? Who is the authority? So they came down to say that they'll recognize associations in the county based on the largest number of members. So a new association was formed in Baltimore County. And they basically adopted in 1966 a new bar association entitled the Baltimore County Bar Association, Inc. was adopted in February of 1966. And the idea was, are they going to be recognized as the new bar association for Baltimore County? And legislation was actually passed limiting the recognition of new associations. And along with that, compromises were made as to how people became members of the executive committee, how you basically ran this association. It wasn't until 1966 that the first African-American attorney was admitted. And at that time, a motion was then made and passed to allow female members to attend the annual banquet. I guess, you know, we look at the 1960s as sort of a turning point for law generally, with Supreme Court decisions that revolutionized criminal practice, criminal procedure, how we came to look at the practice with respect to the codes and pleading, and all those rules sort of changed over in the 1960s. I've always admired attorneys who sort of practiced under the old rules and then were able to adapt their practice with all the changes that occurred in the 1960s and 70s. Because frankly, I don't think in the 35 years that I've been plus a member of the association and been practicing, that any such great change has occurred in the 10-year period, let's say from 1960 to 1970, in the way law was practiced. And I often think of how difficult it must have been for someone like Judge Rainey, who was a state's attorney in the 1950s, became a judge in the 1960s, to be a judge throughout all those years of turbulence, turmoil, and having to learn essentially new procedures and new rules as if he were in law school. It must have been an incredibly difficult kind of thing to sort of pull up. The new fee schedule was finally abandoned, or the fee schedules were finally abandoned in the late 1960s. They got a basic opinion that said, gee, fellas, maybe this is something you might want to give up now. It appears to be illegal. But we published it. It just wasn't mandatory on attorneys any longer. We had a lawyer referral fee in 1967. The first half hour was set at $25. And we had the Young Lawyers Committee, was formed in 1968.